Hello everyone, welcome back to the second lecture of Administrative Law. I am Rajni Yadav and I'll be teaching you today Administrative Law. As you all know, in the last lecture we discussed what is an administrative law, what is the purpose and policy behind it, and the basic principles of administrative law, like rule of law, separation of power, principles of natural justice. Now, in today's class, we'll be reading further in administrative law, and we'll be starting it by judicial review. It is also one of the very important topic in administrative law. So yeah, let's start. We do not have now what's happening in India. Earlier, when there was a king system and all, so there used to be a police system. But now we do not have police system anymore. Now we have a welfare state, because of which the government, the intervention of government or the government functions have increased. Therefore, we have the requirement of judicial review as well. So it is the judicial review has been called as a potent weapon in the hands of judiciary. Okay. The duty of an administrative body is to not make such laws, rules and regulation, etc., which violates, abridges, contravenes the Part 3 of Constitution, because then it will not be considered as a law under Article 13 of the Constitution. Right? So by judicial review, there is a direct check and balance on the administrative body by judiciary. Objective of judicial review. So now let's see what is the basic objective of judicial review. It is to ensure that the authority does not abuse its power and the individual receives just and fair treatment. Now, let's read some cases. Now, let's read a case law which is related to judicial review, which is Minerva Mills, versus Union of India, 1980 Supreme Court. In this case, it was held that judicial review is the soul of the system, because without it, democracy and law and rules of law cannot be maintained. Parliament has created an independent judiciary which is vested with the power of judicial review to determine legality of administrative action and the validity of legislation. They also said that it is not an appellate power, but supervisory power. Judicial review is not concerned with the decision making, but it is concerned with the decision making process. Right. Now, another case which is related to judicial review and which is very important, it is Keswanand Bharti versus the state of Kerala. It's a 1973 Supreme Court judgment in which it was held judicial review is not only an integral part of the Constitution, but also a basic structure of the Constitution, which cannot be abolished even by the amendment to the Constitution, right? Now, let's see what are the cases in which judicial review can be done. It can be done when the authority has exceeded its power, when authority committed an error of law, when the authority did not follow the principle of natural justice, and when there was abuse of power by the administrative authorities. Now, there is an important concept of Droit Administratif, which we must read when we study administrative law as a subject. Right, so let's see what it is. It's a French concept. So basically in France, matters concerning state and administrative litigation is decided by administrative court and not by the ordinary courts. So for this, they have special courts, special administrative courts, that is Council de Etat. Droit Administratif does not represent principles and rules laid by the French Parliament. It consists of rules developed by the judges of administrative courts. So there is no code of droit administrative like the code civil. The Council d'Etat has developed and elaborated the doctrine on its own, right? So what they're saying is, it is a French concept, and in France, whenever there's a matter with respect to the administration, or where there is a dispute with respect to the administration, then it does not go to the ordinary court. It goes to the court. It goes to a special court which is created there, which deals with administrative law matters, and that court is Council d'Etat, right? Now the next thing that we are going to read for this subject is Doctrine of Legitimate Expectation. This term was first time used by Lord Denning in 1969 in the case of Smith versus Secretary State for Home Affairs. So by this doctrine, it is intended to give relief to people when they are not able to justify their claims on the basis of law, though they have suffered a legal consequence because their legitimate expectations have been violated. So what they are saying, this doctrine is intended to give relief to those people when they are not able to justify their claims on the basis of law, though they have suffered a legal consequence. That is, the people have suffered some legal consequence or legal loss, but they are not able to get the relief which they really wanted because they are not able to justify their claims on the basis of law, because as their legitimate expectation was violated, right? It is actually based on the principle contained in Article 14, which is against the principle, which basically talks about arbitrariness, right? Which says there should not be any arbitrariness, right? So it is basically the hope or the desire of a person to obtain a favorable order inspired by past practice or promoted by the representation. So what it is saying is that it's a hope or the desire of a people. Basically what they say, it is the legitimate expectation, with what like legitimate expectation, the prudent expectation, which the common man can expect from the past practice and from the past practices which are being going on, right? So what it is saying is, the past practices which are going on, based on them, any normal man will have some expectation, will have some legitimate expectation. So this concept is still in a revolutionary stage, basically. The doctrine of legitimate expectation was finally settled in a case law, which is Monet Ispat and Energy Limited versus Union of India. In this case, it was said that this doctrine of legitimate expectation is founded on the principle of reasonableness and fairness, and also on public interest in executive policy or law. Legitimate expectation should be justifiable, legitimate, and protectable. It cannot be invoked if it has the effect of jeopardizing public interest for the private benefit. That is, you cannot jeopardize public interest when you are talking or when you're claiming for your legitimate demands or when you're putting forward your legitimate expectation, you cannot hamper or jeopardize the public interest. It shares space with promissory estoppel and principles of natural justice. Right. Now, another concept that we are going to read under administrative law is the doctrine of proportionality. This doctrine came in 19th century in Europe and originated in Prussia. Actually, it says action should be proportional to the desired result. This doctrine has replaced Wednesbury principle. Right. Earlier, we used to have a Wednesbury principle, but now this principle has been replaced by this doctrine of proportionality. So what was Wednesbury principle? Actually, Wednesbury principle was laid down in the case of Associated Provincial Picture House Limited versus Wednesbury Corporation, 1948. So Wednesbury principle is a principle which is a test of unreasonableness. So what we when we talk about Wednesbury principle, we are basically talking about, we are testing for the unreasonableness, right? So now under this doctrine, proportionality is a 3 steps check. So when you talk about this doctrine, what are the things that you will check? So 3 steps are there, which 3 things are there which you check under this doctrine. It is 1, first is means check, other is ends check, and third is proportion or balance check. What does means check means? Means check means to achieve this end, what are the means taken by the administrative authority, right? So what are the means or the tools or the things were used by the administrative authority to achieve this end? That is what they're talking. End check. We have a purpose to be achieved by administrative authorities. So end check is, what is the purpose that these administrative just a second. So when we talk about administrative check, we basically check what is the purpose which these administrative authorities are aiming to achieve. The third check is proportional and balance check, whether there is a balance between the means and the end. So under the third check, you basically check the balance between the means and the ends. Now, when we started this class, we discussed about judicial review, right? So now we will read what is the judicial review procedure. How do you go for review, right? So how do Supreme Court or High Court exercise their power of judicial review? Of course, it is through writs that the courts go for review. There are 5 kinds of writs, right? The first one is certiorari. If there is any order passed against you and you feel it did not follow the principle of natural justice, or it was unconstitutional, unreasonable, it was arbitrary, and the order which was so unconstitutional, arbitrary, or against the principle of natural justice, that order could be judicial order, quasi-judicial order, or can be judicial order, quasi-judicial order, or administrative order, right? And can also be an order from administrative action as well. Then this order can be quashed. So what they're trying to say is that if there is an order passed by judiciary, quasi-judicial body, or by some administrative body, and that the order is unreasonable, unconstitutional, or against the principle of natural justice, then that order can be quashed. Right? Case law under this will be AK Kripaya case, which the facts of which we already discussed in the last class, in which they said that the selection board has taken an action, right? So what happened in this case? The order passed by the selection board was quashed. Why? Because it was against the principle of natural justice. If you remember, we discussed about personal bias. So on the ground of personal bias, it was quashed, right? So it is talking about that because it did not follow the principle of natural justice. So that order was quashed. Now, what are the grounds for quashing such order? It can be quashed on the following grounds: when there is a lack of jurisdiction, when there is excess of jurisdiction, when there is abuse of jurisdiction, violating the principle of natural jurisdiction, or an error apparent on the face of record. Right? By lack of jurisdiction, they mean there was no jurisdiction, still you tried that matter. Excess of jurisdiction, you went beyond your limit. When abuse of jurisdiction, you did not decide it on the merits of the case, or there was some miscarriage of justice, right? So these are the grounds on which the order can be quashed. Fine. Now let's go to the other slide. The second writ that we are going to discuss is prohibition. It is similar to the writ of certiorari. It is almost similar to the writ of certiorari, that there will be a judicial order issued by Supreme Court or High Court to a body to prevent this body from continuing the proceedings, right? That is, herein you are prohibiting here what you're doing is you're prohibiting the body from continuing its proceedings. It will be judicial order wherein you'll be prohibiting from continuing their proceeding. So what is the difference between certiorari and prohibition? The main difference is of one point, that under certiorari the proceedings had already completed, but in prohibition the proceedings are going on. That is, there in certiorari the proceedings had terminated. Here, when the proceedings are going on, then you are passing this order and you're prohibiting them from moving ahead. Okay. Now let's go to the next writ. Mandamus. By this writ basically means to direct or to command. Mandamus is a judicial remedy issued in the form of an order from the Supreme Court or High Court to any agency to do or refrain from doing a specific act, right? It's an order. So what basically it is, it's an order to an agency to do or to refrain from doing a specific act, which that agency is obliged to do or refrain from doing under the law, which is in the nature of a public duty or a statutory duty. So basically the conditions of this writ are: there must be a public duty created by a statute. specific demand to fulfill that duty, and refusal to do that duty. Right? So what is it? There was a public duty created by the statute, and there was a special demand to fulfill that duty, and there was a refusal to do that duty. Right? So, and the right subsisting in the, and when you file the petition, when you file the writ petition, when you file the writ petition, when you filed the petition, writ petition, your right was still subsisting. Suppose it happens. Just a second. Yeah. Suppose there's a road in front of my house and the road is broken. So whose duty it is to maintain that road? Right? It is the duty of the municipality to maintain the road. So, so now what I do is I file a writ petition of mandamus, by which the municipal authority will direct the concerned authority to repair it. Right? So what? Here what is happening? So there's a public duty created by the statute. It is their duty to create a good and a good road, so that any vehicle can pass through that road, right? And specific demand, since the road was not in a proper condition, I demanded to repair it, right? Specific demand to fulfill that road, and refusal to do that, they did not repair it. So right, so when they did not repair it, so I had a right to file a petition to get it repaired. So this is what mandamus means. Okay. Now, next writ. But now there's one more thing to this writ. Now there's a new concept which is emerging nowadays. It is continuous mandamus, which is this concept has been developed by the Supreme Court so that it could oversee the implementation of its directions to the administrative authority, which at times is necessary, especially when fundamental rights of the people are involved, because contempt proceedings are technical and time consuming. So what is this continuous mandamus? It is basically when the writ has been issued and the concerned authority has been directed to take the required action. So what court can do is, in between, they can oversee if they are implementing with the orders of the court or not. So when they are just seeing their work in between the process of their work, so this is called continuous mandamus. That is, court can oversee the implementation of its directions to the administrative authorities. Now, the last writ that we'll be discussing is quo warranto. By what authority or by what warranty? Sorry, this is second last, fourth writ. So this is by what authority or what warranty? Example, there's an officer who receives his termination notice. Still, he does not vacate his office and continues to be in office for 2 days. And in those 2 days, he passes all wrong orders. So now quo warranto will be filed against him. As in, he will be asked in what authority he passed those orders, right? So the conditions for this writ are, there should be a public office, and the office is permanent in nature and which is not terminable at will. The person must be in actual possession of the office, and the office is held in contravention of law. So if these conditions are fulfilled, then only you can file the writ of quo warranto. Public office should be there, and the person must be in actual possession of the office, an office held in contravention of law, right? Now the last writ is habeas corpus, which means you must have the body. Which means you must have the body. If this writ is not there, then Article 20 will be of no use, right? So this writ gets its existence from Article 21, which talks about right to life and personal liberty. Under this writ, physical confinement is not necessary. Just a second. Under this writ, physical confinement is not ready. Wait. Just a second. I'm not able to get the cursor. Give me a few seconds. For what? I'll not be using the cursor because it's really creating a lot of trouble. I'll not be using this pen, right? We'll be reading, just focus on the cursor, right? I'll be pointing through the cursor. Yeah, so we were discussing habeas corpus, which says you must have the body. This writ gets its origin. This writ gets its origination from Article 21, which talks about right to life and personal liberty. Under this writ, physical confinement is not necessary. In fact, mere control, physical control over a person or on personal liberty is sufficient to file this writ. It is very frequently used in minors and minors' marriage. Court calls and asks for justification for confinement or physical control. If the party is not able to justify as to why they have confined or they have put the person under some control, physical control, then the court will ask to release the person so confined. This writ cannot be suspended even during emergency. Okay, there's a very important case law in this under this writ, and which is Sunil Batra versus Delhi Administration, 1980 Supreme Court. In this case, Justice Krishna Iyer opened new vistas for the issuance of this writ, as it was issued on the basis of a letter written by a convict to one of the judges of the Supreme Court alleging inhuman torture to a fellow convict. And that letter was taken as a writ petition. Under this case, actually what happened, new approach was given as to how the writ can be filed. So in this case, what happened, there was a convict. He wrote a letter to the Supreme Court judge, giving details about the inhuman torture which was given to his, one of the co-convict, to one of the fellow convict in the jail. So this letter of his was taken as a writ petition. Now let's read this PIL. Now we will be reading PIL under administrative law, which is public interest litigation. The idea came from Roman jurisprudence, which is actio. It's not action, it is actio populis. That is, courts access to every citizen in the matters of public wrongs. What does actio populis means? That courts should be accessible to every citizen if something wrong has been done to that person. Right? So now, this concept first originated in USA, and in India, first time it was introduced in 1980. And the architect of this concept are P.N. Bhagwati and Krishna Iyer. In Indian context, the inspiration of PIL comes from the oath which a judge takes to defend the constitution. Right? When you read the jurisprudence, that every citizen has a right to protect himself, or if anything wrong, if any wrong has been done to him, he has the right to get the justice from the court. Right? So it is, and who sits there? Who are the ones who decides? It is the judges only now who decide or who protects the right of the people, no? So it takes inspiration from the oath which a judge takes to defend the constitution. Right? Professor Upendra Bakshi in Indian context said that SAL is more appropriate term rather than PIL. What that is, he was of the opinion that the terminology which should be given to this concept is social action litigation. He found it to be more apt. He found it to be the more apt, SAL to be the better name for this concept. Right. Now let's read why PIL. Right. Why should we go for PIL when we have normal procedures and process to go for our case to be adjudged and decided? So now let's read one by one. Because lack of availability of common public law. And the second reason is expensive legal fees, right? Because when you file any normal case in any normal and ordinary course, you have to pay certain fees. So here it is not so required. So right. So here it becomes inexpensive, and lack of proper legal knowledge. While filing it in the normal courts, you need to follow a lot of procedures are there which you have to follow. But even here, normal person can also file a PIL, a letter also, it can be filed, right? Even by writing a letter to a judge describing about your problems or sufferings, that can also be taken as a PIL, right? In emergency situation, also it can be filed. It is an extrajudicial remedy. It's a part of judicial activism. High courts and Supreme Courts deal with it. For filing a PIL, locus standi is not required. That is, any person can file it. It's not necessary that the person suffered or going through some loss, he only or she only has to file the case. No, anyone on his or her behalf can file this PIL. It should not be politically motivated. PIL should not be politically motivated, and it should always be filed when no alternate mechanism is available to get the justice. PIL basically deals with human rights, and PILs are to claim rights against government or private action, right? They can be filed to claim a right which is against government or private action. A PIL can also be filed for welfare of large masses. So I have written pointers you should learn and read and learn them. Now let's talk about the next concept, which is delegated legislation. What is delegation? Delegation is basically when you delegate, or when you give some power which you have to somebody else to do your work, right? You're delegating your work to other. You are empowering somebody else to do your work. So this is delegation. So, and now we are going to read delegated legislation. So it is to give somebody with the legislative power, right? And it basically, generally it is given to the executive, right? So under delegated legislation, you are giving the law-making, rule-making power to somebody else. Why delegated legislation? See, basically what happens is, normally Parliament is the body which is making rules and laws. They have to make rules and laws for so many things, so many debates are going on. So Parliament is already so much burdened with their business. So what it sometimes does is, it delegates its work to other agents to do their work, right? And it requires handling by experts. Sometimes what we see is that in Parliament, basically ministers are sitting, and many of them are not even literate, and many of them do not have knowledge about particular subject matter on which rule is required to be made. So when you hand over your job of rule making to some other agent who is well qualified and well read and understood in that particular field, so it is good. No, they will make a better and comprehensive legislations and rules, right? Parliament can't foresee the difficulties which may be encountered in the execution. Sometimes it happens, the parliaments are not able to foresee the problems which might come out of the legislation which they are making. So when you delegate it, when you delegate your work of legislation to some particular agent, they do not have workload. They just have to focus on one thing. So they can go very deeply and read what could be they can go about all the apprehensions and what could all difficulties might come with the legislation. So yeah, so if you'll delegate them, they can make a very comprehensive and good legislation. Delegated legislation also introduces flexibility in the law in the cases of emergency, right? Let's say it's like this. Let's take understand it in a common parlance. If you do some work on the advice of your parents, always you take advice of your mother and father while or before doing anything. And what if some emergency arises? So you should also have some you should also have some critical understanding as to what could be the pros and cons of a particular situation. So if you will if under delegated legislation, there is flexibility in the cases of emergency, right? So that is to say, delegated legislation introduces flexibility in the law in the cases of emergency. That is, if any urgent or emergency arises, and you are handing over your legislation rule making power to somebody, they might make laws as to what is required in that particular situation or at that particular time, right? Now let's read about the constitutionality of the delegated legislation. In the case of Re-Delhi Laws Act 1912 AIR 1951, Supreme Court upheld the constitutionality of the delegated legislation, and this case was called as the Bible of delegated legislation, right? Now there's a maxim under this topic, which is delegatus non potest delegare, which means sub-delegation is not allowed. You cannot give your delegation power to somebody else, right? But sometimes in some legislation, there are some enabling acts which allows sub-delegation. So in those situations, in those legislations, you can even sub-delegate, right? Now, you have to see that power of delegation is limited. And when you have power to repeal or modify legislative policy cannot be delegated, because these are important legislative functions. That is to say, important legislative functions like to modify or to repeal cannot be delegated. For example, now let's understand. I'll explain you with the one example. We have the Environment Protection Act, right, which was made by the legislatures, right? But under that law, we have state and central pollution control board, right? And they have been given the powers to make rules and regulation with respect to the environment law. So, right, so EPA, the law was made by the legislature, but herein by this law, through the enabling act which was there, it has enabled the board, that is state and central pollution control board, to make rules and regulation. That is, you're giving executive, you are empowering the executive to make rules, right? So you are here delegating executive with the powers of legislature to legislate. Right. Now, let's read liability of administration in cases of tort. In the cases of tort, with respect to administration, vicarious liability of state for tort is committed by its servant is based on principles of. So basically, what will happen? Vicarious liability will be there of the state, right? If any tort is committed by the servant, and it is based on two principles. First is respondent superior, that is, let the principal be liable, and the second one is qui facit per alium facit per se, that is, he who does the act through another does it himself. Now let's read about the mechanism for handling the grievances against administrative fault. Mechanism for handling grievances against administrative fault. Under this, we'll be covering three things. The first one is Ombudsman. The second one is Right to Information Act 2005. And the third one is CVC. So let's start with Ombudsman. This concept was developed in Sweden. The first time this concept emerged in Sweden in the year 1809. So you must know where this concept came from, where it originated. Sweden. It is asked so many times in so many exams, so you must learn this thing. What is Ombudsman actually? Ombudsman is basically a watchdog of the administration, or the protector of the little man, the protector of the common man. In India, it is called Lokpal at central level and Lokayukt at state level. The seats for Lokpal and Lokayukt were sown in the year 1963, but it was in the year 2003 that the Lokpal and Lokayukt Act was passed by Anna Hazare movement. The first Lokpal was Justice Pinaki Chand Ghosh. He was elected in the year 2019, right? The present Lokpal is Pradeep Kumar Mohante. So you must remember and learn, first Lokpal was Justice Pinaki Chand Ghosh in 2019, and the present Lokpal is Pradeep Kumar Mohante, right? What is the purpose of Ombudsman? Purpose is administrative acts within that the administration acts within its power, and there is no corruption in administration, right? That is, the administrative bodies should act within the ambit of their powers and there should not be any corruption. Now let's read the second one, right to know. Yeah, before Right to Information Act 2005, we used to have Freedom of Information Act 2005, right? So public authorities are required to make disclosures on various aspects of their functions and structure, right? It is the duty of public authorities to make disclosure of their various aspects or to make disclosure with respect to their functioning and structure. So yeah, and you can in fact question them. If you have any doubt, you can ask them questions regarding their functioning and structure. And in case you do not get the satisfactory reply, you have the right to appeal to the Chief Information Commissioner, right? And so what is the procedure? How do you file cases? How do you file under RTI, right? First, you go to PIO, that is Public Information Officer. And suppose if you're not satisfied with their answers, you can appeal against. You can again appeal. You can go in appeal. And suppose even in appeal you're not satisfied, then you have the right to approach the CIC, that is Chief Information Commissioner. Our present Chief Information Commissioner is Yashvardhan Kumar Sinha. Yashvardhan Kumar Sinha is our present CIC. Now let's read the third one, CVC, that is Central Vigilance Commissioner. It is, this position was recommended by Committee on Prevention of Corruption, that is Sanatan Committee was set up, and it gave recommendation on prevention of corruption. And this committee was appointed in 1962, right? And in 1964, we got our first CVC, that is Central Vigilance Commissioner, who that post was attached to Ministry of Home Affairs. It was a non-statutory body back then, but then there was a case called Vineet Narayan versus Union of India in 1997, Supreme Court. It was by Supreme Court, it was made a statutory body by this case law. So earlier it was a non-statutory body. Now by Vineet Narayan case in 1997, this has been made a statutory body. It is the highest body to deal with matters related to corruption. And you should know, they might ask in question, who is the present CVC? So our present CVC is Shri P.K. Srivastava. So that's it. That's all for today's class. I hope you really like the section. Thank you so much.